Today we will discuss the procedure for getting the remedy, or you can say the special forum that has been created to resolve the dispute of the cyber wrong under the Information Technology Act. And if you remember, I have said during my introductory class and during discussion on section 43 and section 43 capital A also, that for these wrongs one need not to go to the court for getting the remedy, but the legislature has created a special forum, a dispute resolution mechanism, and through that mechanism a forum has been created, that is the adjudicating officer. And the proceeding before this forum are very simple, because this forum is not a civil court, so it will not follow the Civil Procedure Code 1908. And so in a very less time, the dispute is resolved, because court will take the time. Court has to follow the Civil Procedure Code. Okay, but then another question comes in mind, that in the courts we have judge, that is legal expert, and here what is the guarantee that the person who will sit as an adjudicating officer will have the knowledge of law or not? Okay, and so in this particular class we will discuss this procedural aspect, and to discuss this all these thing we will find out the answer of 8 questions that I have framed. The first thing that we want to find out, that where to file the complaint, because we learned and we have this idea that it is before adjudicating officer, no need to go to the civil court. So in civil court, before civil court we use the plaint, suit. Okay, यहाँ पे complaint word use होता है. So where to file the complaint, whether there would be only one adjudicating officer in the whole country, or at the district level, or at the state level. Okay, that means the jurisdiction of the adjudicating officer, and accordingly we will get the answer of the question where we will file the complaint. The second thing is, we will discuss here, along with this jurisdiction, territorial jurisdiction, the pecuniary jurisdiction also. So the pecuniary jurisdiction, like if you remember, or if you have an idea of your the civil law classes, sometimes the jurisdiction is classified in pecuniary basis also. If the claim is of up to this threshold, then to the lower court, then above then this threshold to the high court, district court, and more than that to the high court. Okay, then the third thing we will discuss here is the pro forma of the complaint, that what actually we have to write in the complaint, because it is not the plaint. Okay, for the plaint we have the Civil Procedure Code. In the Civil Procedure Code, what we have to write in the plaint, there is whole law on that, and accordingly we can prepare. So what to write in the complaint, and a draft pro forma also. The fourth thing is, in filing the suit in the civil court we have to pay the court fee, and there is one statute relating to that, the Court Fee Act. So the question is whether here we have to file the fee also or not, or is it free? And in there is nothing free. Even for the RTI you have to pay. So here also is the fee, but how that fee has to be calculated? The next thing, the fifth thing, is about the duplicity. In the Civil Procedure Code we have the res judicata, section 10 of the Civil Procedure Code, that if at one place a person filed at the court, then he cannot file the case on another, because the it is hit by the res judicata, section 10. Here also there is provisions or not for the duplicity. And obviously there must be the provision, otherwise it would create the confusion. Then the next is about the frivolous complaint. Like in the Civil Procedure Code, you will find the provision with respect to if the complaint, the suit is filed or any application is filed with only purpose to harass without any substance. So here about the frivolous complaint, because there is always fear that how much better method we are providing, there may be the possibility that someone will use for their only to satisfy their grudge, to settle their score. And the seventh one is like the compromise decree. Suppose the complainant filed the complaint against the person, suppose A, and A, before he has to prove before the adjudicating officer, he said that yes, I has committed the wrong and I want to pay whatever compensation you award, damages you award. So the compounding of wrongs, like the manner of the compounding of the offenses also, where the offense can be compromised. Section 320 of the Criminal Procedure Code. And then the last point is the procedure. Because Civil Procedure Code will not apply. And so there is the question, can the adjudicating officer decide the dispute without hearing both the parties? Without providing the hearing? Biasness rule. All those rule of the principle of natural justice, P&J. So whether they has to be followed or not. If they has not been followed, because it is the administrative law well settled principle that the principle of the natural justice has to be followed by any adjudicating or quasi-judicial forum. That another question regarding the procedure, that before the civil court, one always speak truth, because there is the consequence. If one tell lies, then there is the criminal action can be taken, that is offense of perjury under Indian Penal Code. But this adjudicating officer office is not the court, and in that case the IPC provision will not apply. And so what is the guarantee that the witnesses will depose truly? About the execution, for the execution there would be the order of the decree of the court. What would be the procedure for the execution of the order awarded by the adjudicating officer? Order 21 of the Civil Procedure Code talking about execution, one of the largest order in the Civil Procedure Code. But that would applicable only when it is decree of the court. And for other things also, there need to be clarity on that, because Civil Procedure Code is not applicable. Okay. So these 8 questions we will try to solve, or we will try to find out the answer in this case. I just frame, in this manner so that this lecture can be interesting and you guys will understand it. What the provisions we are going to discuss here? We are going to discuss here section 46 of the Information Technology, that is before you. And the second is the rules that are framed by the central government with respect to the qualification and experience of adjudicating officer and manner of holding inquiry, rules 2003. In these rules there are 12 rules, but that are very important to understand this topic. So these 2 things we will discuss here. First is about that if there is any cyber wrong like section 43 or section 43 capital A, there are some provisions where there is a penalty, civil penalty, कि वो जुर्माना होगा, ये जुर्माना होगा. So that penalty power, that is not criminal, that is not punishment, not the like the under section 66 or etc. Penalty. Okay, so that power is also given to the adjudicating officer. So for that, first we have to read section 46 subsection 1, that will give the answer that who will adjudicate for wrong committed under the IT Act. Yes, any of you please read.
Which section are you talking about, sir?
Section 46 subsection 1. I just shared the screen, you can read from here also.
Okay, sir. For the purpose of adjudging under this chapter whether any person has committed a contravention of any of the provisions of this act or of any rule, regulation, direction or order made thereunder which renders him liable to pay penalty or compensation, the central government shall, subject to the provisions of subsection 3, appoint any officer not below the rank of a director to the Government of India or an equivalent officer of a state government to be an adjudicating officer for holding an inquiry in the manner prescribed by the central government.
Yeah. So section 46 subsection 1 is basically giving answer to the two questions. One that is important for us, that if there is any violation, contravention of the provision under this act or rule for which there is liability of the penalty or the compensation, so it's important for the compensation portion, section 43 and section 43 capital A, then the adjudicating officer is competent to hold the inquiry. How he hold the inquiry, as per the manner that we are going to discuss. Who will be the competent, who will be the adjudicating officer, this provision also giving some answer of or some glimpse of that also, that the adjudicating officer has to be appointed by the central government. Okay, by the central government shall, and then officer not below the rank of director in the Government of India if that person is working in Government of India, or if that person is working in the state government, then that equivalent officer of the director will be adjudicating officer. So the first question, the answer of first question we get, that where we have to go, we need not to go to the court, but we have to go to the adjudicating officer. Now this special office, this special forum, dispute resolution mechanism has been established, but there is a fear in our mind that whether this person who was appointed and who is the stature of the director in the central government or the equivalent rank in the state government, but whether that person will be competent to decide the dispute under IT. A person would be competent when he has first the legal expert, legal knowledge भी तो होनी चाहिए, and the second thing कुछ IT की knowledge भी उसे होनी चाहिए. Okay, and so this provision in itself is not giving the answer. A person would be most suitably to do or act as an adjudicating officer when he has this type of the qualification. And for that we have to go to the rules framed by the central government in this regard. I am sharing the rules also, and here these rules, rule number 3 talking about the more about the qualification or eligibility. Yes, please, any of you read this section, rule number 3.
No person shall be appointed as an adjudicating officer unless he possesses such experience in the field of information technology and legal or judicial experience as may be prescribed by the central government.
No, rule number 3, I am not saying clause 3. Rule 3 that I just shared, the rule that framed by the central government with respect to the qualifications of adjudicating officer and the manner of holding inquiry, rule 2003. If you see the shared screen, you will find here that these are the rules. It's through the notifications came in 17th March 2003, and then there are these rules. Okay.
So whereas the purpose and intent of section 46(3) of IT Act is that the adjudicating officer should be person so qualified and experienced to take decision with a view in relation to information technology aspect, as well as in position to determine the complaints, keeping in view the legal or judicial mannerism on the principle of compensation of damage of IT Act.
Yes, yes.
A person shall not be qualified for appointment as adjudicating officer unless the person possesses a university graduate, bachelor degree or equivalent degree recognized by central government, state government for the purpose.
Yeah, I'm just reading now. So thank you. It's saying that rule 3 we have to read with the section 46 clause 3 that just he read, that as we earlier also discussed, that the IT knowledge and the legal knowledge. But section 46 subsection 3 is also giving the outline, and unless you read rule 3 of the IT rule 2003, you will not get the holistic picture or the idea about the qualification, or to assuring that the person would be in the best position to resolve your dispute. And so the rule 3 is very important. It's saying that the person shall not be qualified unless he possesses the university graduate bachelor degree, possession of information technology experience in area of relevance to public interference with the central government, and functioning experience obtained through in-service training. Then I'm leaving something. Then the clause C, the possession of legal or judicial experience to discharge responsibilities connected to the role of central government or the state government in respect of making decision. Fourth is D is in working and holding the post of grade 1 government department either at the state or union territory to discharge job responsibility in field of information technology. And the E is in the service of officer not rank of the director, that already we have discussed under section 46 clause 1. So for the the qualification of the adjudicating officer, you have to read section 46 subsection 1, section 46 subsection 3, and then rule 3 of the IT rules 2003, that give the complete idea. And by reading all these qualifications, we are assured that the adjudicating officer has competent enough to decide the dispute under the IT law. Now the second question, that where to file the complaint. IT एक्ट के अंदर हमें एडजुडिकेटिंग ऑफिसर के बिफोर तो फाइल करना है, बट द क्वेश्चन इज दैट वेदर दिस एडजुडिकेटिंग ऑफिसर विल बी एट नेशनल लेवल और एट द स्टेट लेवल और एट द डिस्ट्रिक्ट लेवल, कहाँ पे कंप्लेन को फाइल करना है. एंड फॉर दैट द आंसर इज slightly you get the hint in section 46 subsection 4. I am reading it because otherwise I have to disturb this sharing. Section 46 subsection 4 says that where more than one adjudicating officer are appointed by the central government, shall specify by order the matter and the places with respect to which such officers shall exercise their jurisdiction. So it is possible that there would be more than one adjudicating officer, and if there are more than one adjudicating officer, so the area is defined. Okay, and now the position is that in every state there is an adjudicating officer, and that is the position. It's maybe that in the bigger state, bigger by the area, like in the Goa or Delhi, maybe one office is sufficient, but in the bigger area it is required more than one adjudicating officer also. And for that the question arises that when there are like in the case when there are different courts, we talk about the jurisdiction. section 14, 15, 16, 17, 18, 19, etc. of the Civil Procedure Code talking about jurisdiction. So here is also about the jurisdiction. To which particular adjudicating officer करना है? And for that the answer lies in the rule 4 of the IT rules 2003 relating with the handling of inquiry. Yes, please read rule 4, scope and manner of holding inquiry.
The adjudicating officer shall exercise jurisdiction in respect of the contravention in relation to chapter 9 of IT Act 2000 and the matter or matters or places or areas in state or union territory of the posting of the person.
Yeah, stop here. So first is that the area, the state in which it is posting. Suppose the person is in the Haryana, so maybe he has to assign the whole work of Haryana, or maybe suppose there are 2 or 3 or 4 or 5 adjudicating officer in that particular state according to the convenience of the government. So that particular place that is under its control, like every court have the jurisdiction defined, the territorial jurisdiction. Every police station is also have its territorial jurisdiction in which it will take the action. So similarly that adjudicating officer will exercise its jurisdiction, and it will have the jurisdiction only with respect to the contravention in relation to the chapter 9, that is the civil wrongs. Okay, that means it will not have the jurisdiction to listen or resolving the dispute under like offenses, etc. Okay, then the next question is that suppose there are 2 or more adjudicating officer in a state. So how we will determine? So generally, like in the courts, we have through the territorial jurisdiction, that if the offense is committed in the territory that is under that particular court. So here also suppose there are 3 adjudicating officer in the state A, and all these 3 have divided this territory into 3 division. So the territory where the offense is committed will be determined. So this gives the answer, rule number 4, clause B. Yes, read 4 clause B. The complaint.
The complaint shall be made to the adjudicating officer of the state or union territory on the basis of location of computer system. Computer network as defined in subsection 2 of section 75 of IT Act on a plain paper on the performa attached.
Yeah, stop now. Now it's talking about procedure. So it's saying that the place within whose jurisdiction the computer system or computer network, as the rule 75, section 75 subsection 2. Section 75 section 75 is talking about extraterritorial jurisdiction. It says that if the offender is outside and he is committing the offense that involves the computer resource, so the place where that computer resource is located will be considered as the place of offense. So suppose maybe the offender is in Rajasthan, but the computer resource is in Haryana, and he has, through the hacking, through unauthorized access without physically present in that computer, he made access to the computer and then deleted the file, etc. Okay, so the computer source will determine that where the offense has been committed, not the person who was present there. Okay, so where the computer resource, computer network against whom or to which the offense is committed, that will determine the territory, the jurisdiction, the jurisdiction to which this particular case will go to the adjudicating officer. Yes, Vikash, question?
Sir, yes, sir. See, suppose, sir, we having a computer access in a Delhi, right? But my head office in Mumbai, right? So my main server is located in Mumbai. So any offense I have committed in Delhi, but actually that since server is located in Mumbai, the judicial shall be in Mumbai office only.
Yes, because
Yeah, correct.
it's not saying that like we talk about section 19 of the civil procedure code, that saying that either maybe where the cause of action arises, or where the accused reside or have the place of business, etc. Here where the place of the computer or computer network is there. So if your computer against whom it is situated is supposed in the Delhi, so Delhi will be the place. Whatever be the place of business of that company is irrelevant for that purpose.
Now, for the sake of clarification, sir, see, suppose you are saying that the server main network should, see if I am correct, that you are saying that your main server
See,
location of main network
if the offense is against the server, then we have to see where the server is situated. If the offense, suppose you are making access to my computer, so you will use the internet through it. So that is not that is not relevant, that from which or through which you are making the access. The ultimate what computer network or the computer or computer resource you have achieved, the location of that has to be taken into the consideration for the purpose of jurisdiction.
So basically, you are saying the computer resource is the computer where itself the crime has been committed, right?
Yes, yes. Okay.
Thank you, sir. Thank you.
Yeah. Now the second thing is about that, the second question, that what we have to write in the complaint, the pro forma. See, it's very simple. There is not like the plaint where आपको डबल कॉपी में फाइल करना है, बहुत सारी कॉम्प्लेक्सिटीज हैं, so many things you have to write it. Here is you have to write your name, phone address, then the name of the offender, etc., and simple how the wrong has been committed. And here in the rule I just shared, I just want to show you the pro forma also. See, this is pro forma. I think you are able to see it.
Yes, sir, we are
Okay.
able to see.
Yeah, so the first is name of the complainant. Here the details of the complainant will be written, like the email address, telephone, correspondence, digital signature, if any. Then the second column, the name of the respondent who has committed as for your knowledge. Okay. Maybe if you are not aware, but in that case, in the civil cases you will not get the compensation. And then so you have to know the respondent. Then the third one is the damages claim, that what you want, and accordingly the fee has to be deposited. So this gives the idea that fee bhi hogi. Then the some time of contravention, place of contravention, cause of action, and brief fact of the case, and then the signature. So these simple, in this simple format, or even when we read that section 46 rule number 4 clause B, it's saying that the plain paper or in the pro forma. So similarly, in the plain paper also you can write all these things, and you can make the complaint. So it's very simple in that way. Okay. So the second question is also answered. Third is about the fee. As I said that in the civil action, for the taking the remedy before the court in the suit, we have to pay the fee, and there is the law, the court fee act. Here is the fee for that. There is the rule number 8, and rule 8, and pro forma also giving the hint ki fees to kuch pay karni hai, but how to pay fee, whether it would be through the bank draft or demand draft or cash payment, etc. And to whom the payment has to made, how much it has to be made. So in the fee we will get answer of these three questions: to whom it is made, how it is made, and how much it has to be made. Rule number 8, if you see and if you read, yes, can any of you read it? Every complaint.
Yes, sir. Every complaint of a matter to the adjudicating officer shall be accompanied by fee payable by a bank draft drawn in favor of adjudicating officer in Officer Information Technology Act at the place of functioning of adjudicating officer in the state or union territory, calculated on the basis of the damages claimed by way of compensation from the contraveners on the rates provided below.
Thank you. Stop here. So the first question is answer like in case of fee, that we have to pay the fee to the adjudicating officer information technology if it is the state of X to the state of X, state Y to state Y, or union territory X to union territory X, and this would be in the bank draft. But the third question is कि कितने का बैंक ड्राफ्ट बनाना है, for there is the table that accordingly we have to calculate. Suppose it has to be calculated in the similar manner like the the court fee act. Suppose your compensation you want to seek, the damages you want to seek is 8,950. 8,950. So the first column it's saying that up to 10,000 it would be 10% ad valorem rounded up to the nearest next 100. So what is the nearest next the 100? 8,950. So nearest 800 क्या होगा, 50 का पूरा आप बना दीजिए उसको, तो पूरा 9,000 हो जाएगा, and then the 10% of that. Okay, so 900 rupees will be the fee that you have to make the bank draft payable in favor of the adjudicating officer under information technology of that particular state. And accordingly that table you have to see and you have to calculate it. I'm not going much detail because we have less time and I have to complete all these things. Okay, then suppose there is any application like for the penalty or other thing, then for that there is in the second column the fee for every application is 50 rupees. Even if you see the first line of the rule 8, that every complaint of the matter shall be accompanied by fee, and that give the force to it that without fee the complaint will not be entertained. Okay, now come to the next question, and that is about duplicity. Suppose there is wrong committed by A against B. A has deleted that the manuscript of a book that B has written and has in his computer through unauthorized access, and B want the compensation. So B filed one case at to one adjudicating officer, then the another case to the another adjudicating officer, and so that about the duplicity. Okay, and for the civil procedure code we have there res judicata section 10. Here the provision is the rule under the IT rules, rule number 9, that talk about the duplicity, and this rule is in the form of the res judicata. To avoiding the duplicity there is the direction. Yes, please, any of you read the duplicity clause.
When an adjudication into matter of contravention is pending before an adjudicating officer, same matter shall not be pursued before any court or tribunal or authority in any proceeding whatsoever, if there is already filed a report in relation to the same matter, the proceeding before such other court, tribunal or authority shall be deemed to be withdrawn.
Yeah, so there is the direction shall not pursued before any court or tribunal, etc. So this provision is clear. Here I remember one another point that we just forget it, that about the pecuniary jurisdiction. See, as I said that in the civil courts in different states we have pecuniary limit of the court also. Like in the criminal case, it's not that you are the first class magistrate, you can decide can hear any matter. Okay, so there accordingly how much punishment as per the offense you have you are able to hear the dispute. Here in the civil cases it is through the pecuniary limit कि आपका डैमेज कितना है, आपका सब्जेक्ट मैटर कितना, उसके अकॉर्डिंग होता है. समटाइम इट इज सपोज टू वन थ्रेशोल्ड 0 से 20 लाख. आई एम जस्ट गिविंग एग्जांपल टू द लोअर कोर्ट, then about 20 lakh to 1 crore to the high district court, एंड देन अप टू द हायर कोर्ट. तो इस तरह से जुरिडिक्शंस जो है पेक्युनरी जुरिडिक्शन के अनुसार भी चीज़ें चेंज होती हैं. So here, there is one amendment in the section 46 in 2009, where the pecuniary jurisdiction of the adjudicating officer has been fixed. That is section 46, subsection 1 capital A. I am reading that the adjudicating officer appointed under subsection 1 shall exercise jurisdiction to adjudicate matters in which the claim for injury or the damage does not exceed 5 crore rupees. So the pecuniary limit or the pecuniary jurisdiction of the adjudicating officer, any adjudicating officer, is of the 5 crore rupees. But this provision will lead to the confusion, because generally if the lower forum or if the lower court is not having the pecuniary limit, then ultimately it is decided by, or the upper forum will have the jurisdiction. Now, as I told that here there is the 3-tier structure: adjudicating officer, then to the next chapter, 10th chapter, section 48 read with section 57, appellate tribunal, and then to the section 62 to the high court. So this is the 3-tier structure, special mechanism here. Now, then would it be the cyber appellate tribunal? अगर लोअर को एडजुडिकेटिंग ऑफिसर को पेक्युनरी लिमिट जो है वो 5 करोड़ तक ही है, व्हाट इफ द मैटर इज मोर देन 5 करोड़, हु विल हियर इट? So obviously, it comes mind that higher authority, that means the cyber appellate tribunal, but that is not here. And so the proviso attached to the this section, clear it, section 46 1 capital A proviso provided that jurisdiction in respect of claim for injury or damage exceeding rupees 5 crore shall vest with the competent jurisdiction. So in the case of the damages for more than 5 crore rupees, 5 or 5 crore rupees, exceeding 5 crore rupees, then it would be to court. And to which court? That is competent. Maybe the court that is competent through the territorial jurisdiction also and through the pecuniary jurisdiction also, that court will have the jurisdiction. So there is slightly change here. Otherwise, if this proviso would not be there, generally we would understand then directly the appellate tribunal will hear this matter, but that is not here. Okay, now come to our sixth question, that is what is the procedure of frivolous complaint? If someone has filed a complaint without any cause of action, and that is with malified intention, not in the good faith, malified intention, because good faith is very important. If in the good faith someone has filed the complaint and if that has not been proved, or if that person was not the real offender, so that would not arise to any legal consequence. But if the particular action or the complaint or particular proceeding is started just to harass other person, in that case in the civil procedure code also you will find the consequence. सिविल CPC में 1 से 151 तक सेक्शंस हैं, 57 58 तक, देन ऑर्डर्स और रूल्स हैं. सो वहाँ पे आपको मिलेगा सेक्शन 44 एंड समथिंग अराउंड इट. ओके, सो हियर फॉर द फ्रिवलेस कंप्लेंट आल्सो, टू demote the frivolous complaint or to stop this type of the actions, there is the rule related to frivolous complaint. If a person file a frivolous complaint, that is the rule number 10, it is visible here, you can read it, but I am just telling it, no need to read it. In case there is a frivolous complaint, then it is a discretion of the adjudicating officer that he can award the cost. The cost means against the person against whom the complaint was filed and it was decided as a frivolous, then that person has suffered the losses because he came to defend this complaint, etc. So whatever money he has lost in all these things, so that cost can be applied. The second is that maybe that for that person he has suffered harassment, compensation can be awarded up to 25,000. But what exactly, again, the judiciously adjudicating officer has to decide, taking the different factors into the consideration. The status of the person against whom the action was taken. Suppose एक डायरेक्टर लेवल का आदमी था, वो आया, उसका कितना नुकसान हुआ, और एक सिंपल आदमी है, उसका कितना नुकसान होगा. So it's depend on different things. And even the fine also, जुर्माना भी वो डाल सकता है, fine not exceeding 10,000 rupees. So this is the consequence of the frivolous complaint. Now the seventh one is about the compounding of the wrongs. Suppose the complaint was, yes, I come to your answer, question, Vikas, just let me discuss this. Suppose there is the compounding, suppose there is the wrong committed and the complaint was filed by Mr. X against Mr. Y, but Y does not want that to reply it or attend. He just say that, okay, I want to compound it, just tell me how much damage, how much loss you have suffered, I am ready to pay. Okay, so then it is not that the principle of that the proceeding will done or principle of natural justice will follow or wo proceeding hogi. There is again that this system of compounding of wrong is showing this procedure how quick it is. Okay, and so in that case compounding is also possible. Yes, Mr. Vikash, I just take your question and then come back.
Sir, I have two questions.
Okay.
See, whether cyber appellant tribunal do exist in our country?
See, if you read section 48, earlier, so many provisions has been made. If you see whole chapter 10, okay, section 48, section 49, 51 then. And then the government was not able to establish a tribunal. So what they did, that the tribunal that is already working under the section 14 of the TRI Act, TDSAT, that is also listening the matter from the adjudicating officer as an appellate tribunal, TDSAT. Okay, I think we read one judgment also, you was not there, of the TDSAT, the State Bank of India versus Chandrakalani. The judgment was from the TD. Yes, okay. So that judgment, the similar simple thing like for the competition commission, the appellate tribunal was it was उसकी परिकल्पना हुई थी, but it was not finally constituted. And now the company law appellate tribunal also listen the appeals from the this competition commission, so that company law appellate tribunal also work as the appellate tribunal for the competition matters also. Yes, another question.
Sir, my second question was that whether this adjudicating officer having a power to initiate criminal proceeding as well?
No, this has not been, and this question was raised by Vinod Kaushik also in that first case, that section 66 they have mentioned. Yes, they can impose the penalty, जुर्माना लगा सकते हैं, सिविल जुर्माना जो होता है पैसा भरना है, but no, criminal action it cannot be. And that is clear from the rule 4 also. In the rule 4 also it has written that any contravention under the part 9. If you read section 46 also, there also you will get an answer that any contravention under the act, rules, regulation, etc., where there is the penalty or the compensation. Okay, though nowhere it is mentioning that for the offenses they have the jurisdiction. So it's the civil forum will not have any power to or jurisdictions to see the cyber offenses under chapter 11. Okay, should I proceed, because already
Yes, sir,
okay.
please, sir.
Then the last is the procedural part. What procedure it will follow? See, civil procedure code will not follow, and then there is the question that in that case what would be the proceeding, because it is well settled the administrative law principle that for the any tribal that may not be strictly have the court, or maybe sometime have the trapping of the court, or the quasi judicial system has to follow the principle of natural justice. What are the principle of natural justice? No one can be judged in his own cause, rule against biasness, and no one should condemn without hearing. So section 46 subsection 2 is saying about it that the adjudicating officer shall, giving the person referred in subsection 1 the reasonable opportunity of making representation in the matter, and if on the inquiry he is satisfied that the person has committed the contravention, he may impose such penalty. So this reasonable opportunity means he has to follow the principle of natural justice. Okay, then there is another issue that some power, sometime suppose you summon a person, you give a notice to a person that you have to give the evidence, the court give, and then the person is bound because there are some proceeding, some criminal action will be there. Before the court, person will not do the perjury, will not give the false evidence because there are the criminal consequence. Okay, and so similar things should also be there, otherwise the adjudicating officer will not proper functioning. And so for that there is the subsection 5. Subsection 5 is giving the hint in this respect. It says that every adjudicating officer shall have the power of civil court. Not all the power, shall have the power of the civil court which are conferred by the appellate tribunal under subsection 2 of section 58. For some purposes, for doing proper function like the civil court, have some power are conferred. And what power has been conferred, when we will discuss the appellate tribunal under section 58 clause 2, similar power is having the adjudicating officer also. Along with that also, all the proceeding under before it shall be deemed to be the judicial proceeding, shall be deemed to be. It's a legal fiction. Wherever it is shall be deemed to be, that means actually it is not. It is legal fiction. The fiction created by the law for some purpose. So it shall be deemed to be the judicial proceeding within the meaning of section 193 to 228 of the Indian Penal Code. And when the proceeding before the adjudicating officer is through this legal fiction or the judicial proceeding, so then speaking lie is consequence of perjury, action again under IPC section 193 section 228. Okay, then the clause B, I will take just 5 minutes just to complete it, then I will take your questions. Okay, shall be deemed to be civil court for purpose of section 346 and 347 of the criminal procedure also. Again there is deeming provision. And then as I in the earlier also I have said that if the order is passed, how it has been executed. For the court order, civil court, there is the proper proceedings, proper rules related to execution, order 21. Here that shall be deemed to be civil court for purpose of order 21 of the civil proceeding, and so it would be deemed to be the civil court, and the order of this adjudicating officer shall be the order of the civil court, and the execution is also possible in the similar manner. For the execution you can go to the civil court also, that this is the thing you have to execute, like the order of any civil court, decree of any civil court. So this is about the proceeding, and with this the topic with respect to the proceedings before the adjudicating officer is clear. Okay.